just sort of trying to wrap up sort of the pre-exam aspects, what sort of do's and don'ts based on what you've been seeing would you suggest the audience be considering when preparing for examinations, whether state or federal?
So I'll start with a few of the do's. I think whoever in your organization is managing the exam process, they need to know the organization extremely well. They need to understand the roles and responsibilities of the different business units, and most importantly, they should know who the subject matter experts are within your business areas who can respond to questions and produce documents. When the regulators come, you don't want to be fumbling around and trying to figure that out. Because the regulators are going to expect very prompt responses, and I understand the CFPB will often give you only 24 to 48 hours to respond. I think another thing you should be prepared for is to really understand the vulnerabilities in your businesses and where you might have compliance issues, because you want to have ready explanations for how you're addressing those. The regulators are much more forgiving if you've self-identified these issues and are working to address them. And then a third do I'll mention is go over your previous exam reports and make sure you've adequately addressed the findings from the prior exam. Now just a few don'ts. Don't be antagonistic, don't hide the ball, and don't be arrogant. Those attitudes will definitely not set you up for success.
I have pretty much the same do's, so I'll focus on some more don'ts. Don't ask for extensions. That's something that you really want to wait and use if it's absolutely necessary. So that means pushing your folks in operations to get everything they need, including answers to questions. Sometimes you have to do digging and short turnaround times, especially with a shorter term state examination where they may be on site for 3 or 4 days. You don't want an examiner leaving with questions unanswered, because unanswered questions could result in findings for something that really isn't a violation. So that's important to make sure you have that. I don't think you should have legal counsel participate in examinations. Lynn and I are both reformed lawyers, and I think that we both feel comfortable enough to participate in the exam, but there's a different level of animosity that I think comes with having a separate legal counsel in that defined role as a participant in the exam. It definitely doesn't run as smoothly as it would without them. And you know, as Linda said, don't learn about anything during the exam. When you go into litigation, you don't want to learn anything at trial. You don't want to learn anything when the regulator finds it. You should have gone through the documents yourself and determined that whether there's been a violation, or if something doesn't show up very clearly, do the research ahead of time to that and say why there's something that doesn't look correct, and I get an explanation before they even ask.
And Richard, one of the things you mentioned when talking about attorneys in the exam, I mean, as you mentioned, both of you are reformed attorneys. You know, for those institutions that perhaps don't have, you know, attorneys leading their compliance operation or organization, do you think that still stands? Where do you think you draw the line on that kind of involvement, and who do you think should be involved?
Well, I've had experiences in the past where legal counsel actually explained the law to an examiner, and that was about the worst situation. We've had predecessor at a prior company with the state of New York said you're allowed to attend, but you can't speak, and lawyers can't not speak when they see something that there's an issue. So it led to animosity, and the exam was over for that session. So I don't think they should be involved unless there's enforcement from a regulator. If there's an enforcement attorney on the other side, then my position changes.
Yeah. You know, one of the questions we've gotten that I think can fall into kind of the pre-exam context is many of the CFPB guidelines and exam procedures are very vague, but the examiners have had very specific ideas for what it will take to satisfy these requirements. Where can we get detailed outlines for what the CFPB will want to see? And I don't know that necessarily you can answer where do they find these, but I think the question that I would pose to you is, how are you dealing with, in preparing for the CFPB, how are you dealing with any sort of vagueness or uncertainty that you find within any of the handbooks, examination guidelines, etc.?
Well, I'm sure many of you do this as well, but we pay very close attention to enforcement actions that the CFPB or the FTC or whoever it might be, even the bank regulators issue. And we use those as a roadmap. And so when one comes out, we'll examine our own policies and procedures and our practices and try to determine if we have any similar issues that arose in that particular enforcement action. And the CFPB has actually said or encouraged all of us to pay very close attention to those enforcement actions because they're probably not going to issue many regulations.
And there's actually a number of great compliance organizations where you could speak to peers and see what they are seeing. And this summit is actually another good example of where you can actually ask some of the questions of peers that may have been through the ringer on some of these questions to see, you know, what does this mean in this example. So I think that's a good way to learn about what those interpretations could be.
So the combination of resources that are out there with any sort of peer review type things plus consent orders and other types of guidance that you may see makes sense.